Hello, everyone. It is such a pleasure to see you all here today. Welcome to today's Year in Review panel on democracy litigation in the U.S. Supreme Court and state Supreme Courts. We really appreciate you all being here, both in person and virtually. My name is Miriam Seifter. I am a law professor at the University of Wisconsin Law School, where I am also faculty co-director of the State Democracy Research Initiative, and I'm very happy to be your moderator for today's event. This event is jointly hosted by the State Democracy Research Initiative and by the University of Wisconsin's Elections Research Center, which is directed by Professor Barry Burden. We are very grateful for their partnership and also for generous sponsorship from the Wisconsin law firm Stafford Rosenbaum. To introduce our amazing panelists today, I'm going to turn the floor over to Erin Deely, a partner at Stafford Rosenbaum. Erin.
Good afternoon, everyone. Yes, my name is Erin Deely. I am co-chair of the Election and Political Law Group at Stafford Rosenbaum. We are a full-service firm. We handle, family law, business law, municipal law, you name it. Our election political law group has had the privilege of representing parties in several of the pro-democracy rulings coming out of the Wisconsin Supreme Court this term, including Evers v. Markline and Call v. Ermansky. Needless to say, all of us at Stafford are thrilled to sponsor this series and, particularly excited about today's presentation. Today's panel, Year in Review, Democracy Litigation in SCOTUS and the States, is sure to not disappoint. First, we have Dean Erwin Chemerinsky. Erwin Chemerinsky is the Dean of Berkeley Law School, having served in this position since 2017. Prior to his appointment as dean, Dean Chemerinsky was the founding dean of the University of California, Irving School of Law. He was professor at Duke University, University of Southern California Law School, and DePaul College of Law. He has authored 19 books, including leading case books about constitutional law, criminal procedure, and federal jurisdiction, and is the author of more than 200 law review articles. He is also a regular contributor and columnist with the Sacramento Bee. He is an appellate advocate and has argued before the United States Supreme Court. He has received his BS at Northwestern University and his JD at Harvard Law School. Thank you for being here. That was a lot of deans. Attorney Bo Duell. She is special counsel for the Arizona Governor Katie Hobbs. Before taking that position in 2023, she served as senior counsel at the United States Democracy Center. Prior to that, she was the state elections director and general counsel in the Arizona Secretary of State's office. Attorney Duell is a former partner in the political law group at Perkins Coie and clerked for Chief Judge Theodore McKee on the U.S. Court of Appeals for the Third Circuit. She received her JD from NYU School of Law and a master's in public affairs from Princeton University. I'm going out of order, but I think you guys can all follow. Professor Tara Grove. Professor Grove is the Vincent and Elkins Chair in Law at the University of Texas School of Law. Professor Grove's research focuses on the federal judiciary, interpretive theory, and the constitutional separation of powers. Among her various appointments in 2021, Grove served on the Presidential Commission on the Supreme Court of the United States, a bipartisan commission created by President Biden charged with examining proposals for Supreme Court reform. She has published numerous law review articles, receiving awards for both her research and her teaching. Prior to becoming a professor, she clerked for Judge Emilio Garza on the U.S. Court of Appeals for the Fifth Circuit, and then spent 4 years as an attorney for the U.S. Department of Justice, Civil Division Appellate Staff. Professor Grove graduated from Duke University and Harvard Law School, where she served as the Supreme Court Chair of the Harvard Law Review. Attorney Kasia Wolfkot. Kasia Wolfkot is the senior counsel in the Brennan Center's Judiciary Program, where she works to realize a fair and inclusive judicial system that protects fundamental rights, democratic values, and the rule of law. She is the managing editor of the State Court Report, a Brennan Center publication focused on state courts and the state constitutional law. Attorney Wolfkot previously worked as an appellate attorney at the MacArthur Justice Center. Before entering public service, she worked at Patterson, Belknap, Webb, and Tyler LLP, where she managed the firm's pro bono clemency and parole projects. Attorney Wolfkot is a graduate of Skidmore College and the University of Michigan Law School. She clerked for Judge Carl E. Stewart of the U.S. Court of Appeals for the Fifth Circuit. Prior to law school, Wolfkot worked as a journalist in Moscow, Russia. A super impressive panel. I hope I got that all correct. Thank you for coming and enjoy.
So this is clearly going to be an incredible discussion, so I'll keep my remarks very brief. But the first thing I want to say is that there are 5, I'm counting them, seats in the front. 4 seats in the front and several people standing in the back. It's really fine. You can come all the way up. No one's looking. Just come on up and take your seat. We want everyone to be comfortable. Okay, so I'm going to do 2 things before we really get started. One is a little bit of obligatory housekeeping. For those of you in the room, please be aware that this panel is being live streamed. The event was approved for 1.5 Wisconsin CLE credits by the Board of Bar Examiners and for 1.25 Minnesota CLE credits. Will conclude at 4:15 p.m. Central Time. For those of you who are here in person and would like CLE credit, there are sign-in sheets at the registration table immediately outside this room. Please make sure to sign those before you leave today. For those of you who are participating virtually, please listen for the passcode that I will absolutely remember to give at 4:05 p.m. Central Time. We will provide a link at the same time to a Google form in the chat on the Zoom. You will need to complete that form with the correct passcode by 8 p.m. Central Time today. In addition, for everyone, we will save time at the end of the panel for questions from our audience. If you're here in the room, you should have an index card near you. You can go ahead and just write your question on the index card. We'll have folks coming around. If you are participating virtually, please use the Q&A function on Zoom, not the chat, but the Q&A function to submit your questions, and I will get through as many of those as I can. So that was the housekeeping. Second thing is just a really brief statement on why we're here and why this event, which is a year in review of the courts, seems like an appropriate way to kick off the new year of our Election Matters series. Courts play a very significant role, as you may be aware, in shaping the future of democracy. And that's true on issues from redistricting to voting rights, to the administration of elections, to the rule of law, and whether and how people can hold their officials accountable. So we wanted to devote an event to reflecting on what has been happening in the courts as it pertains to democracy. But the conventional end-of-term event, which focuses only on the Supreme Court of the United States, strikes us as woefully incomplete because state courts, as many of you know, decide the vast majority of cases in the United States, and state Supreme Courts have issued very important decisions affecting elections and democracy. So we wanted to talk about state Supreme Courts too, as well as the interaction between the state and federal judicial systems. And we are so thrilled that this distinguished panel is here to have that discussion with us. So I will start by asking each panelist to kick us off with some opening reflections on the past year, highlighting a case or cases or a trend or theme that we should know about. After that, we'll turn to Q&A with questions from the audience and from me. If you are here in person, we would like to invite you to stick around for a brief reception after with some refreshments when the panel concludes. If you are at home, we hope that you will raise a glass in our honor. Okay, so we will go, for this purpose, we'll go down the line, starting with Erwin, then Tara, then Kasia, and then Bo. Please take it away.
Thank you. It's such an honor and a pleasure to be here. I want to thank Miriam and Dean Dantakaji for inviting me to speak, part of this distinguished panel. In terms of overview of the term, every July I write a short book for the American Bar Association recapping the term that end. And I try to find a theme that unites the many cases and then make it the title of the book. My title for this year is Supreme Court, October Term 2024, Taking Sides. Our country is more ideologically divided than it's been at any time since Reconstruction. Many of the cases on the docket this term reflected that ideological divide. There are many cases about what we would call the culture wars. There are many cases that were challenges to President Trump's unconstitutional actions. Almost without exception, the Supreme Court came down on the conservative side of the divide. In all the culture war cases, in almost all the Trump cases, the Supreme Court took the conservative position. I think one of those profound questions that we have to think about is, at a time when our country is so ideologically divided, what does it mean to have a Supreme Court that is so consistently and solidly come down on one side of the ideological divide? Now, with that said, the case that you asked me to talk about is one that the Supreme Court didn't decide this year. So it not only doesn't fit my theme, there's no ruling to talk about at all. But it's a case that could be profoundly important with regard to the law, democracy, and more generally, civil rights law. It's a case called Louisiana versus Calais. It was briefed and argued this year in the Supreme Court. Everyone expected the decision. And then on Friday, June 27th, after the court handed down all of its other blockbuster rulings, the Supreme Court said it was being put over for re-argument next term. The Supreme Court usually decides everything argued in a term by the end of June, or at least the beginning of July. But there have been instances in the past where the Supreme Court has put cases over for re-argument. Brown versus Board of Education was argued to the court in the October 1952 term. It wasn't decided. It was put over at October 1953 term. And there was a key change. Chief Justice Fred Vinson died in the summer of 1953. And many believe it was the appointment of Chief Justice Earl Warren that made all the difference. Roe versus Wade was argued in the Supreme Court in October term 1971. Because the court didn't have a full complement of justices, they put it over. And it was argued again in October 1972 and then decided in January of 73. Citizens United versus Federal Election Commission was argued and then put over. There's a pattern here. Cases that are put over for re-argument like this often lead to blockbuster rulings. That's why it's worth focusing on Louisiana versus Calais, even though it wasn't decided by the court. Here's what it's about. After the 2020 census, Louisiana, like all states, redrew its lines for congressional districts. Louisiana has a third of its population being Black citizens, but out of the 6 congressional districts in Louisiana, only one was a majority Black voter district. A challenge was brought to this as violating Section 2 of the Voting Rights Act, 1965. Section 2 says that state and local governments cannot have election systems and practices that discriminate against voters of color or against certain language minorities. In 1982, Congress amended Section 2 to make clear that proof of a racially discriminatory impact was sufficient to show a violation. There didn't have to be proof of discriminatory intent. And the Supreme Court has said that districting can be challenged under Section 2 of the Voting Rights Act. The court has articulated a 3-part test in Thornburg versus Jingles that it reaffirmed just recently in Allen versus Milligan. And so a 3-judge federal court, which is used under the Voting Rights Act, found that the map that was drawn by the Louisiana legislature with only one majority Black voter district violated Section 2 of the Voting Rights Act. It went back to the Louisiana legislature to draw a new district. They drew it so there'd be 2 majority Black districts in Louisiana out of the 6 congressional districts. Immediately, a group of, quote, and I'm using their language, non-minority voters brought a challenge to that and said that this new district, where there'd be now 2 out of 6 districts majority Black, violated equal protection. In 1993 in Shaw versus Reno, and in 1995 in Miller versus Johnson, the Supreme Court said that the government can't use race as a predominant factor in drawing election districts. Otherwise, unless it meets strict scrutiny, it violates equal protection. And the challengers said Louisiana, in drawing these new districts, violated equal protection. The Supreme Court stayed the ruling of the 3-judge court that found this to be a violation of equal protection and allowed the new districts to be used in the 2024 election. But the Supreme Court granted review. And the underlying question is, did it violate equal protection for Louisiana to draw 2 majority Black districts? Did it impermissibly consider race as a predominant factor in districting? The Louisiana legislature went for the Supreme Court and said, we can't win. We draw it with 1 district, we get sued and it gets struck down. We draw it with 2 majority Black districts, we get sued and the 3-judge court strikes it down. Just tell us what we're supposed to do. Here's the issue, though. Section 2 of the Voting Rights Act, by allowing discriminatory impact to be sufficient for violation, would seem to require that race be considered. How else can the government make sure that it's not violating the Voting Rights Act? On the other hand, If race is considered as a predominant factor in districting, does that violate equal protection? Justice Alito had previously raised this over a decade ago in a case called Abbott versus Perez coming out of Texas, saying there's a real tension between Section 2 creating disparate impact liability and equal protection that says that race can't be used as a predominant factor in districting. At the oral argument, the conservative justices were raising this. Well, it's possible that what the Supreme Court will then say is that race can't be considered under Section 2 of the Voting Rights Act, and you can't have disparate impact liability, at least when applied. But if the Supreme Court goes there, then the implications transcend voting rights. There are many laws that allow liability on the basis of disparate impact. Title VII of the 1964 Civil Rights Act does for employment discrimination. The 1968 Open Housing Law does. Is the court going to suggest that any disparate impact liability is unconstitutional because it requires that race be considered as a predominant factor? In 2009, in a case called Ritchie versus DeStefano, Justice Scalia wrote a concurring opinion. It was about Title VII, where he suggested that disparate impact liability might violate equal protection because it requires considering race as a predominant factor. The fact that the Supreme Court put this over for re-argument and didn't decide suggests that this could be a blockbuster ruling with enormous implications for civil rights law.
Thank you so much, Erwin. Tara?
Thank you so much, and thank you to Miriam and to the dean and all those who put this together. And thank you all for being here on a lovely afternoon. I have to say, coming from Texas, I did not expect it to be this warm in Wisconsin. So thank you for that. It's absolutely lovely. So I'm going to talk about a procedural issue, one that is actually getting a lot of attention, and that's the issue of so-called universal or nationwide injunctions. A big case issued by the Supreme Court that actually was decided by the Supreme Court this term. Although it's interesting what the court didn't decide. So as many of you may know, on January 20th, President Trump issued an executive order on birthright citizenship. Now, the 14th Amendment of the United States Constitution, Section 1 of the 14th Amendment, actually the first sentence of the amendment, says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Seems pretty straightforward. You're born in the United States, you're a citizen. Well, President Trump's order says you might not be. He says that even if you were born in the United States, you're not subject to the jurisdiction of the United States if your biological mother was an undocumented person at the time of birth, or just here on a temporary visa. So this also applies to people with just student visas. And your biological father was also not either a U.S. citizen or a lawful permanent resident. Well, this executive order has gotten a lot of attention. It went immediately to court. And a bunch of district courts said, I think 3 different ones said, it's probably unconstitutional, and we're going to enjoin it throughout the country. As the Trump administration has done with many things, it took the issue ultimately to the Supreme Court. But in this case, the Trump administration didn't actually defend the constitutionality of the executive order. It didn't say, hey, we're right, they're wrong. What it said was, the procedure is wrong. The remedy issued by the courts is not okay. The federal courts don't have the power to issue universal or nationwide injunctions. And so that turned out to be what the case was actually about. So what is this issue of universal injunctions that people talk about so much? Well, one of the things I want to underscore is this is an issue that doesn't have an obvious partisan valence. Democratic and Republican administrations have been complaining about universal or nationwide injunctions for at least the past 10 or 15 years, maybe longer. During the Obama administration, many of you may remember that President Obama sought to give deferred action to many undocumented immigrants in this country so that they could stay here and get work visas. One of those executive actions was subject to a nationwide injunction. During the first Trump presidency, federal courts issued nationwide injunctions against many things that President Trump did at that time, including the travel ban that was issued in various iterations. During the Biden administration, federal courts issued nationwide or universal injunctions blocking some of the student loan relief the Biden was trying to give out to students. And there were competing nationwide injunctions on mifepristone, a drug often used in abortion. A federal judge in Texas enjoined a rule that would have made it easier to get mifepristone. Another federal judge said, no, you actually can't change what's happening with respect to mifepristone. So this has been happening all over the place. And what do we do with that? So there have been a lot of arguments for and against these universal injunctions. Some people say, hey, it violates the Constitution. Article 3 of the Constitution allows federal courts to do things that are related to the case before the court. And so the court can't go off and do things that apply to the whole country. But that's a very hard argument to make when you start looking at some litigation that federal courts deal with, and some really important litigation that actually connects to some of what Dean Chemerinsky was saying. So for example, if somebody challenges the racial segregation of the schools, that can't be changed without affecting the makeup of the entire school district, both the people that sued and everybody else who happens to be in that school district. And of course, when Brown versus Board of Education came down, there had to be broad and wide-ranging relief that applied to lots and lots of people. When you're dealing with districting, if somebody complains about a single problem with a single district in a state, to fix that problem, you may have to redraw every district in that state, or at least affect a whole bunch of people who aren't party to the suit. So it's hard to say that Article 3 puts a hard and fast rule against broad relief. But still, there are lots of practical objections and practical benefits. So just to notice some of the benefits. Universal injunctions can provide really quick relief, and they can stop unlawful government action and potentially protect individual rights. I think many people saw the birthright citizenship litigation that way. One has a right to birthright citizenship. A universal injunction against the executive order protects that right. It also deals with a problem I'm going to kind of come back to, that it's really hard to do something in the procedural world called getting a class action certified by the courts. It's just really hard. Universal injunctions are easier. And one could say it supports the legitimacy of the federal judiciary to step in and block a really wayward executive. But the cons. It is a single federal district court judge somewhere in the country deciding something that affects the entire nation. Do people in Wisconsin want judges in Texas deciding everything that happens with the federal government? Do people in Texas want the state of Massachusetts or the state of Washington, a single district court judge deciding that stuff? Because it gives a lot of power to individual federal court judges, it also means forum shopping. Why do I mention Texas? During the Obama and Biden administrations, many people went to Texas to file suit thinking they might find friendlier judges. During the 2 Trump administrations, people have gone to Washington State, California, Massachusetts, because they think in those states they're going to find friendlier judges. This may not be itself good for judicial legitimacy. Also puts a lot of pressure on cases going to the Supreme Court without any real division among the lower courts, what we call percolation, where we have lots of different judges coming up with lots of different ideas as to how to address an issue. That's much harder with nationwide injunctions. You also have the problem of conflicting nationwide injunctions. What is a president to do, as the Biden administration was faced with, when one court is saying you can't use mifepristone and another court is saying you have to? And we do have these rules and procedure called the class certification process. It seemed to circumvent that. So all of this was kind of before the Supreme Court in the birthright citizenship case, Trump versus Kasia. And the court decided to take up this issue rather than dealing with the merits at all. And what the court said was, okay, we think federal courts have some power to award relief, even potentially broad relief, but not this power. They said under the Judiciary Act of 1789, if I were in my Fed courts class, I would be quoting Hamilton, 1789. And that would wake them up. Under that old federal statute, the court says, okay, there is some equitable power, but not this power. The court actually did something that it's been doing in a lot of other cases, saying, hey, we're going to look at the specific history that existed in 1789 and see if there are any historical analogs that look like this. And they said there weren't. Now, Justice Sotomayor said in dissent, this is a really messed up way to deal with legal analysis. The whole idea of remedies, especially in this equitable context, is to be able to change over time in response to changes in the world, one of the changes being the huge amount of presidential action we've had recently. But the court majority said no and said this is a really important limit on the federal judicial power. Now, what I think is really important about this, one of the things I think is important about this decision is what the court didn't decide. The court didn't rule on whether these things are okay as a constitutional matter. So they didn't address that Article 3 question at all. The court didn't say whether people could use a separate federal statute called the Administrative Procedure Act to basically block things that the federal government is doing. And that could allow a lot of stuff that looks a whole heck of a lot like universal injunctions. And the court didn't say much about what happens when states sue, which is actually an issue in the birthright citizenship case itself. So there are a whole bunch of unanswered questions. One thing the court did say, though, is that federal courts have to have the power to provide complete relief. And that will go beyond the parties sometimes, as in the desegregation and reapportionment context. So what do we do with all of this? Well, in the birthright citizenship litigation itself, people are going through that other procedure called class certification. And in fact, I learned while I was on a plane this morning coming here, a federal court did in fact certify a class a nationwide class in the birthright citizenship case, found the executive order again unlawful, and basically issued a universal injunction. So it'll be interesting to see what happens there. But one of the things I want to leave you with, and we can come back to this in our discussion, a question that I don't totally have an answer to. The Supreme Court has been faced with this question about universal or nationwide injunctions for years now. The Biden administration asked the court to get rid of nationwide injunctions then. Why did the court pick this case?
Thank you so much, Tara. Kasia?
Hi, everybody. Thank you for being here, and thank you to Miriam and the other organizers for having us. I'm really excited to be here. I am here to focus on state courts and state constitutions. So I'm currently senior counsel at the Brennan Center for Justice on their judiciary team, where I broadly focus on using state constitutions to expand rights. Before that, I was at the MacArthur Justice Center, where I was practicing conditions of confinement under the Federal Eighth Amendment. And I realized during that time, oh my gosh, the federal courts are really hostile places to be trying to vindicate the rights of my clients. And wait, what about state constitutions? Each state has its own constitution. And almost all of those have an Eighth Amendment cognate. Why didn't I ever think about this? Why did nobody ever tell me about state constitutions in law school? So I started trying to do more work under state constitutions then, and realized after that, wait, it's not just the rights of incarcerated people. There is so much in state constitutions that is different than the federal constitution, including the ways that state constitutions can protect democracy. And beyond that, state courts decide 95%, they have the last word on 95% of the cases in this country. So they're really like these sleeper seats of power. So I moved over to my current job, where I just think about state constitutions and state courts all day long. So I'm going to start off with a couple of trends about judicial elections and then move into two major categories, two major buckets of democracy-related cases that state Supreme Courts have decided over the last year. So first trend, we've seen increased spending on judicial elections post-Dobbs, and it is accelerating. So the Brennan Center has been analyzing spending on judicial elections for 20 years. And in the first cycle after Dobbs, 2022, we saw almost double the amount of spending across all states that we'd ever seen in any previous midterm cycle. It was about $101 million across 17 states. And then came the 2023 Wisconsin Supreme Court race, which just shattered records, around $50 million in spending on that one race. And then that was nothing compared to what you all saw here this year, where we saw over $100 million on the one race, including from outside groups associated with national figures on the political scene. So what does this mean? I mean, on one hand, it's an acknowledgement that state courts are increasingly hearing cases with national significance. And it is good that there's heightened attention on these races. You know, maybe people will pay more attention. Maybe law schools will start telling their students a little bit more about state courts and state constitutions.
We're on it.
Yeah, that's right. Yeah, definitely present company excluded from any criticism that you might be feeling. On the other hand, you know, it comes with untraceable dark money, mega donors, misleading attack ads. That can pose challenges to judicial independence and can undermine public confidence in the judicial system. Another trend that we've been seeing is state lawmakers trying to change the laws around how judges are selected with the goal of putting their partisan or ideological allies on state high courts. One of the ways that we've seen legislatures try to do that is moving towards partisan elections. So the Brennan Center hasn't taken an official position as of yet on, you know, in terms of judicial elections, partisan versus nonpartisan. So I'm just going to throw out a few observations that are my own. So data does suggest that partisan elections draw more spending than nonpartisan elections. Partisan elections could be less likely to weed out poor candidates because the partisan signal can be so strong, people just vote along party lines. Ideological divides on courts that have partisan elections do seem to be deepening, becoming more dramatic. We see justices disagreeing with each other. We've seen that on the Wisconsin Supreme Court, some, you know, very sharp words exchanged through written opinions. And it can lead to an impression that the courts are just political bodies, which undermines confidence. So North Carolina is an example of some of what can happen, partially related to a shift to partisan elections. So before 2016, North Carolina used nonpartisan elections to select its judges. At that point, so-called liberals took a majority on the state high court. They won some races by very large margins, and the Republican-controlled legislature then passed a law requiring partisan elections. That led to a Republican majority on the court, which went ahead and revisited cases it had just decided about certain voting restrictions, gerrymandering, and more, and overturned cases they had just decided. Fast forward to the 2024 North Carolina election for a seat on the Supreme Court. Incumbent Allison Riggs, a Democrat, was running against Jefferson Griffin, a Republican. It was a very close race. Riggs won by just over 700 votes. Griffin sought to invalidate her win, to overturn her win by invalidating over 60,000 votes. Now, he didn't claim that any of those voters had committed fraud or done anything wrong. What he claimed was that the rules that were in place that those voters followed were illegal, that the Board of Elections had been operating under illegal rules for many years. So this spurred multiple state and federal lawsuits. A state appellate court sided with Griffin. The North Carolina Supreme Court partially sided with him, partially not. For some of the impacted voters, gave them an opportunity to cure, and for others, just discarded them altogether and then rejected some of his claims. At that point, that was in April, at that point, a federal court stepped in and they permanently enjoined the North Carolina Supreme Court's order, saying that it violated equal protection and due process, federal equal protection and due process. And then 2 days after that, Griffin conceded and Allison Riggs remained on the court. So this was a scary episode. North Carolina came very close to invalidating votes that were lawfully cast. And if that had happened, it would have provided a playbook for elections to be invalidated in other states. It just would have opened the door for all kinds of chaos. So this was a dramatic example of state courts being very involved in the democratic process and being put in a position to uphold or reject our democratic norms. But over the last year, state courts have been involved in tons of cases that implicate democracy. I went through a bunch of articles, cases that we've been tracking at the Brennan Center. We try to track every case in any state that has the potential to have any impact on state constitutional law. So I shout out to my colleague Zoe Merriman, who is the one who does the bulk of that tracking. It's a huge job. So I went through a bunch of those. There's so many categories, and so I just had to pick. So I decided to just focus on, and I'll do this very briefly because I know I've already been talking for a while. So one big category of cases is courts considering cases challenging voting restrictions, and another one is courts considering direct democracy, which is the ability for citizens to put a law or a constitutional amendment on the ballot to be voted on. So over the last year, because there was an election in 2024 in particular, we saw a lot of cases challenging voting restrictions. Unlike the US Constitution, almost every state's constitution explicitly grants an affirmative right to vote. And what ends up happening a lot, a question that comes up a lot, is that state courts have to decide what level of scrutiny do we use when we're analyzing laws that that impact the right to vote, that potentially restrict the right to vote. Strict scrutiny, something else. So in Montana, just two quick examples. In Montana, the Montana Supreme Court said that laws creating voting hurdles violated the state constitution. So these were, making absentee ballots, absentee ballot collection harder, making it harder for students to vote, that kind of thing. And they created a balancing test that wasn't quite strict scrutiny, but was more protective than the federal standard. And then the Kansas Supreme Court went the other way, and they declared that voting was not a fundamental right under their constitution. But overall, we did have more protective rulings than not over the last year. Idaho, Wisconsin, Pennsylvania, Delaware, and Nevada all struck down restrictions on voting or declined to sustain challenges to measures that made voting easier. Second big category of significant democracy-related cases in state courts has to do with direct democracy. So 24 states have some way for citizens to put laws on the ballot to vote, for voters to approve or disapprove. So courts, first, they function as gatekeepers for those ballot initiatives. They're like nonstop asked to decide whether or not proponents followed signature requirements correctly. Did they file the proper paperwork? Could these proposed amendments confuse voters? And those cases over the last year were a mixed bag. And then second, and I want to end on these because I think that they are a real high note. We saw a lot of cases over the last year where legislatures were trying to interfere with citizens' right to put measures on the ballot. And courts across the country came down in support of that right. One of Miriam's colleagues, actually, Derek Klinger, wrote a really excellent article about these cases. So Utah, in a case called League of Women Voters of Utah versus Utah State Legislature, the Utah legislature repealed a voter-initiated statute that prohibited partisan gerrymandering, and the Utah Supreme Court unanimously ruled that there is a fundamental right for people in Utah to enact government reforms through the initiative process, and that any attempt to repeal such a reform had to be analyzed using strict scrutiny. And then in Michigan, in a case called Mothering Justice versus Attorney General, the Michigan Supreme Court considered whether the Michigan legislature violated that state constitution when they used this tactic called adopt and amend, where they adopted some proposed amendments and then quickly changed them so that they said something different. These were about minimum wage and sick leave. And then at that point, it was too late for anybody to vote on them. So it's sort of like a bait and switch. And the Michigan Supreme Court said that that violated the state constitution. So overall, over this last year, there were some big wins for direct democracy, even as we have seen more attacks on that right.
Wonderful. Thank you so much, Kasia. And finally, we have Bo.
Thank you. Good afternoon, everyone. I'm so grateful to be here. So I'm tasked with talking about Arizona, treating the state as a window into democracy and election litigation, as well as, what lessons we can take from what Arizona has experienced. And seems like we're always in the spotlight in terms of election controversies. So Arizona, so many issues, so little time. But I'm happy to report that for the first time in 4 years, Arizona started this year, the year after a general election, without any open court challenges to the election results. So like in the rest of the country, the false claims about election fraud and irregularities that started in 2020 appear to be on a hiatus as Republicans celebrated Donald Trump's win, as well as Republican wins in local races in Arizona and around the country. But that doesn't mean that we had a slow cycle for election litigation. Quite the opposite. We saw dozens and dozens of cases challenging various election procedures. In particular, there seemed to be an emphasis on voter registration list maintenance and whether what counties were doing to kick people off the rolls were sufficient, and early voting procedures, as well as lots of challenges to the state's elections procedures manual, which is the rules that are promulgated by the Secretary of State, the chief election official, and that governs how local officials implement elections on the ground. So we won't have time to go over all of those, but I just wanted to focus on one specific significant issue that is in the national eye right now, and that's documentary proof of citizenship. And then if we have time, I'd want to briefly discuss an obscure case out of Cochise County last year that I think has escaped national attention, but is a cautionary tale and worth flagging for folks watching this space. So starting with documentary proof of citizenship, which I'm going to refer to as DPOC for short. That's what we call it in Arizona. Arizona is the first state to implement a citizenship proof requirement. This issue has been all over the place now. The House recently passed the SAVE Act, which would, among other things, require citizenship proof nationwide. The president's elections EO, among other things, mandated proof of citizenship for federal voter registration forms. And a couple states have recently enacted citizenship proof, with New Hampshire's going into effect before its local elections this year. So there's even more states considering legislation that would do the same. As I mentioned, Arizona, on the other hand, we've required this since the early 2000s. It was implemented through a voter-enacted initiative. In other states, voters can just attest to their citizenship under penalty of perjury. They don't have to provide documentation proving it. So because of a number of court rulings over the last 2 decades on Arizona's proof of citizenship law, we have what we call a bifurcated voter registration roll, and it's immensely complicated. People outside of Arizona, I think it takes people a long time to wrap their heads around it because it's so unnecessarily complicated. You have to provide proof of citizenship in Arizona to be eligible to vote a full ballot. So that's a ballot that has every race, federal, state, local, ballot measures, et cetera. Voters who register but don't provide documentary proof of citizenship, they are registered as what we call federal only voters. So they would get a ballot that only has the presidential race and the congressional and Senate races on it. In Arizona, there's only about 35,000 registered federal only voters. That's about 1% of our entire voter roll. And I'll stress, though, that any actual cases of non-citizens illegally voting are just exceedingly rare. There's no evidence that it's happening at any meaningful level, but it's become kind of a strategy and a trend in efforts to restrict voting. So with that as background, I'll jump into what happened last year in Arizona, the Arizona Supreme Court's ruling on it and where things stand now. And I'll disclose that I was very closely involved in handling this matter for the Arizona Governor's Office when it came up before the 2024 election, and will also disclaim that any opinions I'm sharing now are my own and not the office's. So in Arizona, we have a very voter-friendly version of a citizenship proof requirement because we accept driver's licenses as proof of citizenship, but only if the license is issued after 1996, because that's when Arizona started requiring citizenship or immigration documents to get a driver's license. But if you have a driver's license, that information automatically comes over from the MVD. The voter doesn't have to provide anything. The big problem that came to light last year was that for MVD purposes, if someone has a pre-1996 license, but later on they lose it and they request a duplicate or they go to renew it, the MVD system updates the issuance date to the later date when they got the duplicate or the renewal, because for MVD purposes, that's the date that matters. But what this meant is that when that information was transmitted to election officials, then they would see anyone who had a pre-1996 license but later got a duplicate after 1996 as not having a pre-1996 license, because all they saw was the date of the duplicate. So they treated those licenses as proof of citizenship when they shouldn't have. And that came to light in the summer of last year before the election. And state officials worked very quickly to implement a forward-looking fix to this issue. The computer interface was changed so that when it feeds information to the voter registration system, it keeps the original 96 date. But officials were left with the question of what do we do with the approximately 200,000 registered voters that are impacted by this? So these are people that have been registered for years, who are longtime Arizona residents, and now we're months away from the election, and we don't actually have proof of citizenship for them on file, but they're registered as a full ballot voter. All sides agreed that these voters are probably all US citizens, and the problem is certainly not the voters' fault. But does the law require that they provide proof of citizenship before we let them vote in state and local races in this upcoming election that, is just weeks away from ballots being sent out? It was a serious crisis and a serious issue. In a rare moment of bipartisan consensus on an election issue in Arizona, everyone involved agreed that we needed a quick and clear ruling from the highest court in the state on what needed to be done here. And we needed it in time for election officials to be able to comply with it, and so that this cannot be a reason to challenge the results after the election. So the Maricopa County Recorder sued the Secretary of State in an original special action in the state Supreme Court, and the state Supreme Court thankfully very quickly ruled that county officials could not require these voters to provide proof of citizenship before being allowed to vote a full ballot in November. Without too much elaboration, the court said that doing so is not authorized under state law and would violate principles of due process under the state constitution. It was just simply too close to the election. But the court didn't provide guidance for what to do with these 200,000 voters after the November election. So now, in the aftermath of that, we see politics along with disagreement and confusion over state law and related court orders complicating the solution here. The assumption last summer was that, after the election, the counties are going to require these voters to provide proof of citizenship, and if they don't, then we switch them over to federal-only voters, because that's what should have happened originally when they first registered, were it not for this data translation issue. But ping-ponging court rulings in another case called Mi Familia Vota v. Fontes, which actually went up to the Supreme Court, and the Supreme Court issued an order shortly before this issue came to light, allowing a 2022 Arizona law that says if you register to vote with a state form without providing proof of citizenship, your form can be rejected right away. You don't even get to be a federal-only voter, which is a change in procedure in Arizona. That had been stayed by a lower court, but just months before the election, the Supreme Court stepped in and lifted the injunction on that specific law. So now some of the counties were taking the position that that law that requires rejection of state forms without proof of citizenship, and the Supreme Court's ruling applies not just to new registrations, but also to these 200,000 voters affected by this data issue. We're still dealing with this. We're still unwinding it. The Secretary of State's office was slow and reluctant to give clear guidance and direction to the counties on what to do. So counties were left to come up with their own conclusions. But the office recently requested an Attorney General opinion to try to get uniformity across the state on this, and that request is still pending. So the lessons from Arizona are that for states looking to implement citizenship proof requirements, they should expect to have to spend a lot of time and money to make that requirement work, to implement it and operationalize it. You'd have to modify voter registration offices and voter registration systems, databases. You'd have to educate voters on those new processes. You have to retrain voter registration workers and election workers. All of that's going to be very hard and costly. And some otherwise eligible voters will be prevented from registering and voting as a result. So I think just the overall lesson is that implementing a proof of citizenship requirement, even though that seems to be under a lot of consideration across the country right now, is a massive undertaking. And the chaos and the complications that can emerge even decades after that requirement takes place, it can have drastic implications on elections and really destabilize the process in the lead up to an election. And states need to weigh that against the reality that the problem that this is intended to solve, which is non-citizens illegally voting, that's virtually non-existent, and one that is already addressed through other procedural protections throughout the process, and through very serious criminal penalties that are already in the law. So that is my proof of citizenship crash course. If I can take another couple minutes on the Cochise case, I'll be really brief on it. So this, again, is more obscure. The case involved a county's all-male election that enacted a new tax to build a new jail in the county because their old jail was crumbling. So nobody cared about this outside of Cochise County. But the Arizona Court of Appeals last year found that the county erred by not sending ballots to inactive voters. And inactive voters are voters who have had their election mail returned because their address is bad, or the election officials have gotten notice from another state agency or another state that the voter has moved. So we don't have a good address for these voters. They're moved to the inactive list. The court found that the longtime practice of counties to not send ballots in all mail elections to inactive voters was contrary to state law, and sent the case back down to the trial court to determine whether this error impacted the election results. But because we don't want to overturn the election results unless, even though there was a legal violation found, you don't overturn the election results unless that error actually, we don't overturn election results for technicalities unless it actually impacted the results. But before that could happen, we had the 2024 elections. New supervisors in the county were seated. Those new supervisors were opposed to this new jail tax as a matter of policy. They didn't like the election results. And they negotiated a settlement with the plaintiffs to stop collecting the tax until a new election is, and call a new election on it next year. So in late May of this, the Secretary of State tried to intervene to contest this settlement. But in late May of this year, the trial judge approved the settlement, which essentially allowed the county officials to agree with the plaintiffs in this case to nullify the election results, without any finding, any judicial finding that the alleged error changed the outcome of the election. Cases challenging election results over these kind of procedural flaws have become more and more common, as we all know, but judges rarely order a redo nor do they nullify results, especially without a finding that the errors changed the outcome, impacted the outcome. So I think this is a horrible precedent to set and a roadmap to election subversion when you have the wrong people in control of election processes, especially in light of results of elections for local election officials around the country in recent years. So what really troubled me about this case is that no one tried to intervene on behalf of the voters who voted for this tax, the voters whose votes won the election, and who could have fought to defend the election results. There was no party in the case that was defending the election results. And even though in this case it was a minor issue of little statewide or national significance, I just think it has implications for elections going forward. So it's just a scenario that those of us who care about fighting and pushing back against election subversion should keep an eye on as we go into future election cycles.
Thank you all so much. Let's give our panelists a round of applause for their opening remarks. So it is time now for our Q&A section, but I have none from you. So I would encourage you to write your questions on your index cards, and for those of you on Zoom to submit those in the Q&A box. I do have a question that I'll start out with. Before I get to it, though, I just wanted to plug two resources. If you would like to know what is in your or other state constitutions, we at SDRI run a website called 50constitutions.org. That is your one-stop shop for state constitutional provisions, as well as a function that tracks their history. And a big shout out to my colleague, Emily Lau, who is really the brains and engine behind that operation. And also, if you're not already a reader of Kasia's website, State Court Report, it's an incredible resource for just keeping up with what's happening in state courts. You can sign up for their newsletter like I do and hear from Kasia every week. Okay, so my first question, while questions are coming up, is just to offer panelists the opportunity to respond to one another. It has been a minute since we heard about nationwide injunctions, but something tells me that Dean Chemerinsky is ready to discuss that.
Thank you. I think the bottom line, when you think about nationwide injunctions, is that at a time when we have a president who's repeatedly violating the Constitution in unprecedented ways, the Supreme Court has lessened the ability of the judiciary to check the president. I think Tara is absolutely right. The issue of nationwide injunctions is a difficult one. But I think the Supreme Court's opinion is particularly poorly reasoned and undesirable in result. Justice Amy Coney Barrett wrote for the court, as Tara pointed out, this isn't about interpreting the Constitution. It's about interpreting a federal statute that says that federal courts can hear cases under the constitutional laws of the United States. The statute says nothing about nationwide injunctions. It doesn't allow them. It doesn't prohibit them. Justice Barrett says, in order to answer whether it's allowed under this statute, we should look to whether the practice was permitted in chancery courts in England prior to 1789. And she says, there wasn't an analog then. She also says that nationwide injunctions are relatively new. The first that she sees is in 1963 in a DC Circuit case. And she rejects consideration of practical issues, and she especially rejects consideration of whether it's necessary to check the president. Why should we be focusing on chancery courts in England? As I think Justice Jackson rightly pointed out in her dissent, in England, no court had the ability to stop what the king was doing. Why base our jurisdiction on something from the 18th century in England? Also, there is a dispute among the justices as to whether there was an analog in England, whether the Bill of Peace is an analog. But I thought Justice Sotomayor made a great point and said, courts of equity have always had broad, flexible power. It changes over time. And Justice Sotomayor says, for at least a century in the United States, courts have been issuing nationwide injunctions. I think the majority ignores the practical considerations. If a president does something unconstitutional, like ending birthright citizenship, does that mean there has to be a lawsuit in all 94 federal districts until the Supreme Court rules? Does it mean if some federal district courts declare something unconstitutional, the president can keep doing it everywhere else until either every court rules or the matter somehow gets to the United States Supreme Court? Doesn't it lead to a patchwork? Imagine two babies born in two different districts under identical circumstances. Does it make sense that one's a citizen and one isn't a citizen until unless the Supreme Court rules? But most of all, I think what Justice Sotomayor and Jackson point out is the context of this. It does weaken the ability to check unconstitutional presidential actions. It wasn't a choice between allowing every nationwide injunction and eliminating nationwide injunctions. The Supreme Court could have modified when nationwide injunctions are permissible. Instead, they choose the extreme, eliminating them and eliminating an important check on the president.
Thank you. Any other panelist responses? Kara?
So I think when whenever we have a particular ruling, it's very hard to take it outside the context of that ruling, right? The birthright citizenship executive order is a hugely important executive order. I personally think it's pretty obviously unconstitutional. Seems in tension with the text of the Constitution, the history surrounding the Constitution. It's in tension with over a century of executive and congressional practice, and I am not surprised that every court to have considered the merits has struck it down. And I am still puzzled as to why the Supreme Court decided to deal with the issue of universal injunctions in this case. It may be that because the merits are so obvious, there would be a class certified later on and it was going to be struck down. And so we might as well deal with this issue in this case. But I do think it's important to take it out of that context. And that's why I mentioned the deferred action programs of the Obama administration, the student loan programs of the Biden administration, the mifepristone rules of the Biden administration, and the injunction after injunction after injunction issued against both Democratic and Republican presidents. And I think it's a problem when a single federal district court judge gets to make nationwide policy. And I don't think it's all that good for the judges either. You know, there's been a lot of criticism of that decision as not paying attention to the lower federal courts. I actually think part of what was behind the Supreme Court's decision was protecting the lower federal courts. Every time any administration does something for the past 10 or 15 years, there's one thing I know. Some state is going to bring suit and ask for an immediate injunction against it. Maybe some individuals will bring suit too, but some states certainly will. And that puts tremendous pressure on lower courts, not just to decide issues of magnitude, but to decide them in days. I actually think it's going to be helpful for the courts and for future presidents. So the court has put a pause on this. It hasn't actually gotten rid of really broad sweeping relief. As I said, not only are class certifications possible, but the Administrative Procedure Act may actually allow really, really broad relief. And the Supreme Court's opinion itself says that courts can provide what is necessary to ensure complete relief to the parties. I actually think that the ruling both leaves a lot of room for the lower courts to maneuver and yet takes the pressure off. And I'll say another thing, and I think this has a lot to do with the democracy initiative. Right now, there's a tremendous pressure on our federal judiciary to deal with unlawful conduct. And I am actually quite impressed at how good of a job they're doing in the face of incredible attacks on judicial independence. But here's the thing, judicial independence only works. Political actors only listen to federal court decisions if we have a functioning democracy to begin with. The federal courts cannot save us. We cannot expect them to save us because we only have an independent judiciary if we already have a reasonably functional democracy.
Any other remarks? Or I'll turn to audience questions. Okay. So I'm going to sort of combine some questions. But one question has to do with a potential theme in the panelists' remarks, and maybe I'll start by asking whether you think it's an accurate characterization of your remarks that this is a theme, that courts have become increasingly ideological and polarized. Is that a theme, or are you telling us about some of the sort of like the bad apples or the most noteworthy cases? And then if that is true, if there's increasing ideological action or increasing polarization, what does that mean for folks in the room? What does it mean for law students? What does it mean for practitioners? What lessons should we take away from that? And anyone is welcome to start.
I'll start. I think from a practitioner's perspective, and my experience as the state elections director in Arizona in the 2020 and 2022 election cycles and from the governor's office over the last 2.5 years, I'd say it's a pretty mixed bag, but at least as to the lower courts at both the federal and state levels, I think some of the panelists, as mentioned earlier, have been impressed with the rulings that have come out from the lower courts. The Supreme Courts, both at the state and federal level, is a different story, and I think the polarization may be more apparent and in starker relief there. But from the standpoint of just dealing with the vast majority of cases that affect how state governments work, that affect how local governments work, and how services are provided to our citizens, I think the judiciary has performed well.
And yeah, I also think it's a mixed bag. Across the states, we actually see a lot of state Supreme Courts that rule in surprising ways, that you might expect them to rule according to, whatever ideology you think that the justices have, and they don't. I think Utah is a great example of that. The Utah Supreme Court, I think, has shown a lot of independence and, has put out a lot of really well-reasoned opinions in the last few years, upholding abortion rights, for example. They're very much like an originalist court. They care a lot about the history, but they don't rule necessarily according to like partisan lines. I think the Montana Supreme Court is another great example. I think that they issue unanimous rulings something like 90% of the time. Montana is a state where there have been attacks from the legislature trying to undermine their independence because of what the legislature sees as rulings that are too liberal, but those attacks have thus far failed. So I'm very optimistic. I think there are some courts that are a little bit dysfunctional, but on the whole, I think that the justices in many states across the country are trying to get to the right outcome.
In many cases, the outcome depends on the ideology of the judge or the justices. That's not saying all. It's not even saying most. This isn't new. Think back to Marbury versus Madison in 1803. It wouldn't have come out the way it did other than John Marshall's views with regard to the judicial power. From the 1890s to 1936, we had a very conservative Supreme Court that struck down over 200 federal, state, and local laws protecting workers and consumers. We can talk about what the Warren Court did in ending Jim Crow laws, protecting rights of criminal defendants. It was the ideology of the justices. And right now, we have a particularly conservative court with 6 conservative justices and 3 liberal justices. This isn't just true at the Supreme Court level. When I have an appellate argument, the first thing I want to know is, who's my panel? I argued an en banc case in the Ninth Circuit in September, a police abuse case. I had 6 judges who've been appointed by Democratic presidents, 5 have been appointed by President Trump. I prevailed 6-5. This isn't something that's different at this moment in time. What's different, though, is our society is much more ideologically polarized, so it's not surprising that the courts are more ideologically polarized. And so right now, where you have 6 justices appointed by Republican presidents who are conservative and 3 appointed by liberal presidents, Democrats who are liberal, that's what we get. Imagine Hillary Clinton had won the 2016 presidential election. And imagine she had picked 3 justices instead of Donald Trump. None of the cases in recent years would have come out the same way.
So I think one of the most dangerous developments for the judiciary over the past 10 or 15 or 20 years has been the increasing focus on which president appointed the judge. And just people saying what Donald Trump said in his first term, these are Obama judges and Trump judges and Clinton judges, that's how they rule. They're also so-called judges. And this has been a bipartisan attack right? Democrats attack judges they disagree with. Republicans attack judges they disagree with. And they try to caricature the judiciary as nothing but a bunch of partisans. So Dean Chemerinsky is right. Throughout our history, different judges have had different jurisprudential outlooks. That's why the president nominated them and the Senate confirmed them. Of course, the president and the Senate are thinking about politics writ broad. Franklin Delano Roosevelt wanted judges who would affirm the New Deal. John F. Kennedy and Lyndon Baines Johnson wanted judges, at least at the Supreme Court, and when they could get away with it in the lower federal courts, who would preserve civil rights. Ronald Reagan and George H.W. Bush and so on wanted very different judges. But that doesn't decide how a judge actually handles the job once they're on the bench. It is very easy to look at a small swath of cases that involve really controversial issues and say, hey, they're all political, or to focus only on the U.S. Supreme Court and say they're all political. When you look at the overall work product of the U.S. Supreme Court, it's not easy just based on the president who appointed the judge to figure out how they're going to rule. If you're a Supreme Court watcher, you probably have a pretty good idea. And in fact, one study showed that litigants before the Supreme Court were the best predictors of how cases would come out because they knew how individual judges saw different types of legal issues, the Establishment Clause, the Second Amendment, and so on. But none of this means they're trying to do the partisan dirty work of one political party. And it's extremely dangerous for our society if we start acting like that is the job. One of the most important constraints on the court is the assumption in our society that when you put on a black robe and you have that life tenure and those salary guarantees, you are not out there to do the dirty work of the president who appointed you. You are there to serve the law. Now you're going to see the law in very, very different ways, but that is your job. And sometimes you're going to rule against the president, and they have.
Okay, time flies and we only have 4 minutes left. So this is our CLE moment. If you are attending virtually and you want to receive CLE credit, today's passcode is docket, a place where you can find court filings. That is DOCKET. I believe I got that right, docket. Case does not matter. And there is now a form in the chat where you can complete the CLE information. And again, the password is docket. Okay, so now we have 3 minutes left. So I'm going to ask our panelists a forward-looking question to answer in less than a minute. You have two options. You can either tell us what is one big issue that you will be watching in the coming year. To date, we've been doing a term in review, so now we're going to look ahead. What's one big issue you're watching? Or if you sense some sort of underperformance in the state and federal courts and their role in upholding democracy, what is one change you wish you could make? And I'm happy to go in any order you would like.
Sure, everyone's looking at me. I think in Arizona in particular, but also around the country, the issue of who controls elections is a critical issue. I think alluding back to that Cochise County case I mentioned, an issue worth watching that will have significant implications on the election administration landscape. And I think the likelihood of the power struggle between, secretaries of state versus county officials versus the attorney general versus county attorneys, et cetera, over who gets to interpret, apply, implement election rules and procedures is only increased by the victory of some candidates for these offices who have embraced or at least have been sympathetic to false claims of election fraud in recent years. So just watching them and their decisions that they make and how that impacts voters on the ground is an issue worth paying attention to.
I'm going to answer the second question, the one big change question, and use it as an opportunity to plug some of my colleagues' work. So at the Brennan Center, we also have a group of people who focuses on federal court reform. And after doing an incredible amount of research and surveying, Americans and thinking about what the best thing is to, make the U.S. Supreme Court to increase confidence in the U.S. Supreme Court, they've decided on 18-year term limits, 2 per presidential term, and a binding code of ethics. So if you're interested in learning more, you could go to the Brennan Center's website. They've published a lot of essays and other resources about why they think that those reforms should be implemented.
So I think the best thing for the judiciary as a whole is to shore up our political process. I actually still have a lot of faith in Congress. And if you look over the course of our history, Congress has gotten a really bad rap since about starting the 1980s. People say, oh, they don't try to do anything. I would stop and say, like, why does someone run for Congress? For most people, it's a salary cut. They have to keep 2 homes, one in DC, one at home. They do it because they actually want to probably not engage in gridlock, but do stuff. So I'm part of a Princeton initiative on reclaiming the powers of Congress. And I think the best thing we can do is find checks that are not judicial. And that will be the best reform of the federal judiciary.
I think I'll take your first question. I already mentioned Louisiana versus Calais, which will be re-argued next term. Also, last week, the Supreme Court granted review in 2 cases involving state laws that prohibit transgender individuals from participating in athletics that correspond to their gender identity. This year, the Supreme Court decided United States versus Scrimetti that upheld a Tennessee law that prohibited gender-affirming care for transgender youth. Got less publicity, but in the case on the emergency docket, United States versus Schilling, the Supreme Court allowed President Trump to exclude transgender individuals from the military. I think transgender rights is such an important civil rights issue for our time, and I'm very worried about what the Supreme Court's doing with it.
Thank you all very much. So it is time for me to wrap up this event. I want to thank you all for attending and tuning in. Our next Election Matters event will be in the fall on October 3rd, when you can join us for a discussion of money, politics, and the First Amendment. I want to thank again our partner, the Elections Research Center, and our sponsor, Stafford Rosenbaum. And for those of you who are in the room, please first join me in thanking our panel and then join me for refreshments after. Thank you so much.
It could have been worse, but